My name is Jehan Wan Aziz. I am from UNDP Malaysia, and I have the pleasure of introducing two dear colleagues of mine. On my left, His Excellency Edmund Bon, current chair and representative of Malaysia to the ASEAN Intergovernmental Commission on Human Rights. And to my right, Professor Surya Deva, UN Special Rapporteur on the Right to Development. So I'll do a quick introduction so we can just sort of jump into it. Under Malaysia's leadership this year, AICHR has been setting up to adopt two important regional declarations. First, the Declaration on the Right to a Safe, Clean, Healthy and Sustainable Environment. And second, the Declaration on Promoting the Right to Development and Peace, which I understand will be adopted in the next month or so. The adoption of these two key declarations is taking place against the backdrop of two landmark climate change advisory opinions issued by the Inter-American Court of Human Rights and the International Court of Justice just this past July. So in this session today, we are going to learn a little bit more about these normative instruments, how they interact and what this means for the ASEAN region. Given that we only have 30 minutes, so I'm going to jump right into it. So Edmund, let's start with you. Malaysia, as chair of ASEAN this year, has been somewhat unapologetic about its commitments and meaningfully realizing this vision of an ASEAN-led and ASEAN-owned human rights agenda. Could you tell us more about the declarations? And I want to be a little bit cheeky here. What can we expect them to contain? Thank you.
Thank you, Jihan. Thank you for inviting us and hosting us, and Surya for giving me the opportunity to speak. The ASEAN Declaration on Human Rights 2012 was the first human rights document. It's a non-binding document, a political statement, and you would have known from a lot of the media articles and reports about how it was heavily criticized. But 2012, we had in Article 28F the right to a safe, healthy environment. And this was even before the ICJ advisory opinion and a few other decisions of the courts. So in 2012, the AICHR, actually led by Myanmar, was working on environment for a long time, since 2012. And 3 years ago, Thailand embarked on this project supported by Philippines, Indonesia, and Malaysia to look at a draft environmental rights framework in ASEAN. We are happy to say that in October there will be the Declaration on Right to Safe, Clean, Healthy, Sustainable Environment that has been in process for almost 2-3 years. I took it over as chair to negotiate it, and led by the proponent countries, with the support of proponent countries. And of course, you're not going to expect a legally binding treaty. That's number one. ASEAN doesn't work in that way. Even the strongest sort of treaty, the Hays Agreement, the anti-trafficking instrument, are still not fully implemented, and especially for a right that in ASEAN is still heavily contested. But what you will see is a regional instrument that recognizes a lot of the core principles of human rights, a lot of the core principles of environmental rights. Unfortunately, when we negotiated it, the ICJ advisory opinion had not yet come out. And so real-time events also would have affected it. It would have been better, of course, if the ICJ opinion had come out earlier. But the advocates in AICHR for a stronger instrument, I think, were met with a lot of resistance. And so we had to negotiate it in such a way that we still have international standards there. It's not diluted, but we add value to it through an ASEAN instrument and an ASEAN approach to looking at environmental rights. In ASEAN, we have the AICHR that deals with human rights, but we also have the ASEAN, the ASEAN Environmental Senior Officials Meeting, that deals with the implementation of environmental rights. And we had to do it in consultation with them. But what I think is important is that there is recognition of 1, substantive rights, 2, procedural rights, and 3, enabling of civic space, freedom of expression, opinion, public participation, right to assembly, and protection of vulnerable and marginalized groups, or groups in vulnerable and marginalized situations, as well as looking at access to information. And I think some of you around the room were also part of the discussions as to the rights of indigenous people, UN DRIP. So there is this declaration which we can anticipate in October will provide some sort of a baseline for ASEAN to work up on. And the next stage we'll be looking at a regional plan of action to implement and operationalize the declaration. So just that quick brief overview, Jen.
Thank you so much, Edmund, and thank you also for mentioning rights holders. And I know there were a lot of participation from communities and marginalized groups in trying to put together the declarations as well. Moving to you, Professor Surya, the ICG's opinion in particular was rather explicit. So they mentioned that the climate concern, and I quote, is an existential problem of planetary proportions that imperils all forms of life and the very health of our planet. It goes on to say that a complete solution to this self-inflicted problem requires the human will and wisdom to change our habits, comforts, and current way of life to secure our future. Could you break this down for us and connect the ASEAN declarations with both courts' opinions, and what are the implications?
Thank you very much, Jihan, and good to have Edmund collaborating on this spotlight session. I mean, these 2 advisory opinions are quite long, and I will try to simplify some key messages from these advisory opinions and then try to make connections with the 2 declarations that are being adopted in ASEAN. So it's 2 by 2, 2 advisory opinions and 2 declarations, and how we can move forward. But let me start with an overarching point. I keep stressing the importance of localization of international standards. Because if we talk about international standards as 40,000 feet up there, it is critical if we need to operationalize them to keep in mind the local context, local conditions. These could be political conditions, these could be economic and social and cultural conditions, and I think these things matter, whether we like it or not. So human rights are universal, but it is important to use the local conditions to promote that universality of human rights. So I think that is the overarching, and that's where I'm trying to connect it, what Edward mentioned, that what is the value addition of these declarations. My second point is that we should not have a very sharp distinction between binding standards, the treaty, and the soft standards like declarations. The reason is very simple. In the field of international law, international human rights law, even if you have binding law, in practice it is violated every day. We have conflicts going on in the world. An international human rights law, binding, an international humanitarian law, which is binding, is breached every day. So binding standards in practice could be as good as soft standards. On the other hand, soft standards may in practice may become binding because almost everyone is following them. So I want to start with that we should not say, oh, this is merely a declaration and that's why it will not add value. But let me come to the advisory opinion of ICJ. I think the advisory opinion is crucial because it goes beyond this idea that climate change or environment is a compartment on its own. Human rights law have a key role to play. And that is where the ICJ highlighted that there's a right to healthy climate. That is the advisory opinion of Inter-American Court of Human Rights, my apologies. But in relation to ICJ, the court unpacked that the states have obligation to ensure that both under treaties as well as customary international law to protect the climate system from greenhouse gas emissions. So I think that obligation is very clear. In the context of this Forum on Business and Human Rights, the advisory opinions, both of them, are very clear that the states have a duty to regulate businesses. within their territory and jurisdiction, including fossil fuel companies. So that is very clear. ICJ in particular, but you can find it in the Inter-American Court as well, they talk about access to remedy as well. So if states fail to regulate effectively, there could be a consequence because it will constitute an international wrongful act. So there is a possibility of seeking reparation. There could be guarantees of non-repetition and so on and so forth. So that is crucial. But these advisory opinions also mention two other elements which are relevant. One is international cooperation. We are talking about challenges which no country can deal with alone. And I think that is where this ASEAN declaration will be crucial because it provides a framework, a basis for these countries to come together and collaborate and cooperate. Because the court highlighted international cooperation is a legally binding obligation of states. And I will finish with that, Jihan. The second point that I want to highlight is that the courts try to make a connection between climate change and sustainable development. In the ICJ advisory opinion, the court is saying that sustainable development is one of the general principles that has to be considered in articulating the obligations of the states. And Inter-American Court also highlights the role in its advisory opinion. And I think that is relevant. And the timing of these two declarations is also relevant because these two declarations then can provide a good basis for ASEAN to show leadership in building a synergy between the environment and development. Because often we see a contradiction between the two. So how do you bring them together and break the silos? Thank you.
Thank you so much for that. So both of our speakers have actually requested that we open up for questions from the floor. So please raise your hand if you have a question. Tell us your name, your organization, and to whom your question is directed. All right, we have one here. Maybe we'll take a couple. So we have two so far. Okay, so maybe you can go first.
Okay, my name is Surti Handayani. I'm from PPMAN from Indonesia. We are presented, I'm from Southeast Asia countries. So my question is, what does the declarations mean for us as the peoples? And then the second, when we can see the final draft before signing on October? And since the declarations linking to the international standard, is the UNDRIP also referred for the declarations? Thank you.
I assume this question is for His Excellency.
Two of them.
Thank you for that question. Same question over and over again. ASEAN has traditionally never even had invited CSOs or stakeholders to negotiating meetings. And I want to say from my experience, coming in back to the Commission in May 2024, I was entering the negotiations at the tail end of the ending of the negotiations. There was a working group that was set up by AICHR. And again, the AICHR for the first time set up this working group that included both UN agencies as well as civil society organizations. As would expect in any negotiations, it was a very robust discussion, very frank and sometimes very contentious. And there were 5 working group meetings where civil society and UN agencies were also part of. The issue of UNDRIP and Indigenous people, me looking at the records, I find that there was a lot of discussions on that. And then after the 5th working group meeting, it then goes up to AICHR, and AICHR then decides in our way with stakeholders from the ASEAN bodies. And we had consulted quite extensively with the ASEAN environmental senior officials. So that's made publicly available. So to answer the question, no, you will not see the draft, unfortunately. And the summit in October, we will make it public. I would encourage you to both critique and praise the declaration in any way you think fit. And I think the next stage, for me personally and for some representatives at AICHR, I'm very open to robust critique. It's not a perfect document, but it's only the second human rights document ASEAN has developed since 2012 by the AICHR. So I hope that you will understand it in that context. There is also referencing to indigenous people, if you want me to mention it, but in October, have a look at it. I think it's a groundbreaking document in many ways, although some people might not agree with me. But what's important is not to backslide from that. So in norm contestations, the important thing is whether it's a soft law or hard law, where we have international standards that are basic. It provides a baseline for ASEAN to move upwards, rather than have no commitment at all and only have one line in Article 28F as to right, safe, healthy environment. What does that mean is now elaborated through the environment. But I want to thank civil society. I want to thank a lot of indigenous communities and groups that have come to the working group meetings. And I want to say that a lot of the stakeholders that have provided input, we had something like 100, 200 over inputs, and that I think was distilled by RWI. It was a public draft that was shared online, and I think for ASEAN, this is a step that is unprecedented in that context. So if that's how we have done it, and that's how ASEAN for the first time has opened it up in such a way, I think we must see that as a building block, as a stepping stone, as opposed to not having anything at all. And some other sectorial bodies don't even consult with civil society and stakeholders. So I think we need to see this in this context, and also to understand, I keep saying, not being apologetic, but baselining is very important. A lot of the countries in ASEAN, and now Timor-Leste coming in, do not have similar laws. We do not have similar laws, we do not intend to be prescriptive like the EU. So don't compare ASEAN with the EU, I keep saying. Don't compare ASEAN with Africa. We are not a supranational association, and the association is not an association that was built or was created originally for human rights. It was for peace and security, and now it's transformed in the different ways through norm contestation, and moving forward. I think the important thing is how do you build on the regional plan of action, and that's where ASEAN needs help, because the expertise is not with us. I will say I'm a human rights person, but I'm not an environmental human rights person. So where is the expertise? And sometimes the critique, if I may just give me one more minute, sometimes the critique we have with CSOs that come and with groups that come, and when we have discussions, interfaces with AICHR, is that, yes, you raise Myanmar, you raise Papua, you raise, and then I'm sitting there and say, yeah, we know these issues. But I said, look, I want this document, I want this line, and I said, I want this technical expertise, and say what ASEAN can actually do. And sometimes there's no other response with it. So a lot of the ASEAN bodies that actually look at implementation really need technical help, as opposed to just highlighting the issue and saying, yeah, okay, this is the issue. And we highlight it, of course. Malaysia has highlighted Myanmar all the time. We have highlighted Papua. We have highlighted in all our meetings. And my written statements are all publicly available. So if you say that AICHR has no contest inside AICHR about how we have been doing it, it's not true. I've made all my statements public. I've talked about the conflicts. But when we want to come to technical expertise, we don't have that support. And we need CSOs, we need stakeholders and people to come and support us, because I'm not an environmental human rights expert. That's what sometimes frustrates some of us when we are in the commission. I don't speak for everyone, but there will be other commissioners who have different views, and some of you have already met them. Some of the views are negative, some of the views are positive, but I think the engagement needs to continue. Thank you.
Thank you so much, Edmund. I think a lot of us will be very much looking forward to the launch of the first declaration. Let me take a couple of questions. This gentleman first, your name and where your organization, please, and then let's go over there towards the left.
I am Ashok from India, and my organization is Mines, Mineral and People, working with indigenous communities since 4.5 decades. So here is a question. My question is that how sustainable development protect environment and human right law? Because as per example, like fossil fuel, mining and all this, mining never sustainable. Even hydropower project and all this are not sustainable. So what about the local communities' inherent rights, customary rights, as human rights and environment rights? Thank you.
Thank you so much, Ashok. And your question, will your question be?
And also
Okay. And your question, please, gentlemen. Sir. Oops, okay. You can go first.
already mentioned that I'm not a human rights.
Sure. Thank you. Thank you. Yeah, you can go first, yes.
Good afternoon. So my question is for Edmund, and thank you both for a very insightful, short presentation, but very sweet. Two questions, because I think the ship has sailed in terms of the text of the declaration. But 2 points are, one, at the regional level, what AICHR vision what the process of RPA development would look like. So then us as an academic, CSOs would pinpoint where we can provide support, because you mentioned earlier that you need support, but we don't know exactly where and how to provide support. Second is at the national level, after the adoption, what individual AICHR reps at the national level would do to actually help for the declaration to actually trickle down at the national level, because that's where protection can actually kicks in. So maybe Edmund can share in your own perspective as a Malaysian rep, because also knowing that Malaysia doesn't have right to healthy environment enshrined in your constitution, then how would then this specific declaration on environmental rights can maybe push the needle a little bit further? So yeah, thanks.
Thank you for both your questions. And then the gentleman behind.
Yeah. Thank you, Jozalaba. Namaste. My name is Praveen. I'm from Nepal. I speak as the convener of Asia Indigenous Peoples Network on Extractive Industries and Energy, AICHR, which is a regional network of defenders in 8 countries or territories in Asia, including the ASEAN countries. My question is also for His Excellency Edmund. Yeah, I mean, firstly, I would say we truly acknowledge that ASEAN is moving forward with these declarations, as Edmund has rightly pointed out, transforming it from a closed body to a more human rights based body, towards working for also sustainable development and rights of the peoples here. And personally, also kudos to Edmund that you've been shedding or bringing more transparency on the work of ASEAN and AICHR itself. Unfortunately, AICHR could not engage in the drafting of the declaration because our application for the consultative relationship with AICHR has been delayed or has not been approved for the last whole year. Hopefully, it will be addressed so that we can engage in AICHR works in the coming days and months. But more importantly, my question is, as Edmund has already stated, with this declaration now, which we will get, the communities expect remedy. I think we want implementation of the declaration, even though it might not be the best document that we can get. So, yeah, my question to Edmund again would be how do you think? What do you think communities can get in terms of real impact on the ground with this declaration that has been adopted or that is now agreed? What would be the real change, particularly for the remedy of indigenous communities or impacted communities?
Thank you so much. I'm going to go to Professor Surya first for Mr. Ashok's question. Go ahead.
Okay. I was thinking because Edmund could start, but okay, I can also start. I think the idea of sustainable development in practice has hardly been sustainable. Otherwise, we don't need to discuss this particular issue. So I think that is the challenge. And I think coming back to the self-inflicted part that you were saying, Jihan, earlier, human beings are part of the problem, right? And this whole idea of people-centered development is the crux, because everywhere, UN agencies, governments, everyone, they like this idea of people-centered development. And it may sound attractive, because then you can say, oh, leave no one behind. But I am challenging this idea as part of my mandate. I'm saying it should be a planet-centered approach of development. It has to be participatory, because people are part of the planet, but we are not the only ones on this planet. We cannot leave nature behind. We cannot leave forest, rivers, and mountains behind, and animals behind. So this harmony between people and nature is crucial. Otherwise, we cannot address the inherent contradiction that is there. And I think if we follow this course correction, let me put it this way, then the sustainable development will be in practice sustainable, because it is not sustainable in practice so far. But let me make just one more point, and then Edmund can deal with the specific questions about the declaration. And that is about the trajectory where we should see these declarations. I would also like to mention that as a special rapporteur, me and my colleagues have also engaged with the process. So I think that should be acknowledged, and AICHR and other UN agencies as well, despite all the constraints and limitations. And no document is going to be perfect. So my suggestion is that use this as an opportunity, build on it, don't dismiss it. So take this imperfect document as a building block, use other instruments in the region globally, and then support ASEAN and AICHR. Because Asia Pacific is unique in one way, that we are not one. There is no Human Rights Commission for Asia. So we can build on AICHR and these declarations, despite all the imperfections, and try to operationalize them in practice. And that could be a starting point to build bridges. Thank you.
Thank you, Prof. Surya. So a couple of questions for you, Edmund, on AICHR's vision and localization. And the last question from Prabin on some material impacts to communities.
Yeah, thank you for that question. Windy, I think when we talk about right to safe, clean, healthy, sustainable environment, when we look at the international norms, we're looking at clean air, water, healthy, sustainable, produced food, pollution laws, all of that. NGOs, CSO, stakeholders can already start work on that. Meaning, one, we need a baseline of all the 10 countries and Timor-Leste as to what position of their laws are at the moment in one document. So when you say the elements of the UNGA resolution, UNHRC, the advisory opinion on climate change, what are the legal positions of all our 10 ASEAN member states plus one? And what our position has been when we have been going to the Paris Agreement Treaty negotiations. We need that baseline. We need a baseline report of all the elements that we say is right to safe, clean, healthy, sustainable environment. One challenge we had when we were doing negotiations is that we did not have that baseline, a complete baseline. And we did not have depth in the baseline. We can do a ChatGPT, we can do AI search, and we'll say, okay, Vietnam has this law, and there's just one line. There is not enough depth when we do negotiations, because not all of us are experts in that area. So that baseline needs to be done. After we do the baseline, we need to do the gap analysis. So the gap analysis, you can assume that this declaration localizes, vernacularizes, and implements the UNHRC, GA, and advisory opinion positions. Because the language is wide enough, general enough to apply it. And so if you assume that that's our ASEAN document, what is the next that we need to do? We need to do a gap analysis, and from the gap analysis, what do you want ASEAN senior officials meeting and AICHR together that has representatives from all government sectors to implement in that particular country? So from a regional plan of action, how do we then do it in terms of localization in the particular country? And that requires, again, a gap analysis, right? And what needs to be implemented. But I also want to respond in this second way, and also to Prabin's question. This year, we have had very robust discussions on protection. So Malaysia has pushed a protection shift in AICHR. The protection shift is through our communication mechanism. We have a communication mechanism that is not well known. The communication, and we've been receiving so many complaints this year that we need resources even to deal with it, because some of the cases that we are receiving are just outside our expertise, I need to say. But the communication mechanism provides that protection gateway. And some of us at the Commission have been working together to try and deal with these cases. On Praveen's question, the engagement can always be outside AICHR or can be within AICHR. We have 30 CSOs with consultative status. It's a very rigorous process. I need to apologize that it's taken a year. Your application is not the only application that's pending. We have something like 7 or 8 applications. I'm not sure why this year we suddenly have so many. There was a big jump. When I was rep in 2016, we only had 4. We jumped to 30 in 2018. When I left, it was 30 in 2018. When I came back in 2024, it's still 30. There is institutional blockage there. There are concerns about how, well, there's some concerns of other countries about how CSOs are engaging with AICHR. But I think now we have a new screening panel. I'm no longer on the screening panel because I chair the commission. And it's now, the screening panel is now Indonesia, Thailand. I think Khan is around here, and Laos, Ambassador Yong. So please go and speak to Khan. He's on the CSO screening panel because your application is pending with him. So you want me to be transparent? I'll be transparent. There are a lot of things that we want to try and enhance. Protection this year has been one of the key concerns. And we want to use the declaration, as Surya has mentioned, how we can then get cases that come to us, allowing us to then apply the declaration. And that is not exclusive just for people who are not mentioned in the declaration. It's for all. So I'm just putting it there. I think there is a session tomorrow, right, on this, and we can have more discussions in detail regarding this issue. Thank you.
Thank you so much. So I have received notice that we are out of time, unfortunately. So before I end my session, again, a quick plug for this session tomorrow, titled Climate Change and Sustainable Development from Paper to Practice in ASEAN, where this will be discussed in more detail. And this will be at 1:15 p.m. in the same room. So with that, thank you to my speakers, Edmund and Professor Surya, and of course, thank you to all of you who attended this session.